Welcome everybody to this webinar, and I myself am very excited about this topic. So I can't wait to see what we're going to learn. And I'm glad that you all were able to join us, and I know it's going to be a blessing for us. So next screen, please. I'd like to introduce to you the various conferences that are sponsoring this webinar. And first is Florida Conference and its staff, Phil, Adele, Louis, Maria, and Andrew. And then next slide is the next conference, which is Georgia Cumberland. Nicole and Matthew and Andrew are your contact persons there. Next slide is the New Jersey conference. And we have Carlos and Rachel that are over there helping their constituents. And then the next slide, we have myself and Karina from Kentucky 10. We're always glad to help our constituents with any needs that they have. Then the next conference, last but not least, is the Southern New England Conference, where we have Audrey Falkenberg as the director, April Montoya, and Elizabeth Seymour.
Hello.
So we're always glad to help our constituents.
On mute for the beginning of the meeting.
Next slide, please. We just wanted everybody to be aware that we go through a difficult class that we have to take. It's a law school level class in order to be certified for trust services and plan giving. And our departments are being audited every 3 years or sometimes more often to make sure that we go by the book and we're not doing anything illegal. And that proves quality insurance, And then we have continued education every year. And we have to maintain our certification and learn new things. And that keeps us on the ball here. Next question, next slide. And all the members have certain privileges. Being a member of your conference has privileges. And we'd like to go into a little bit more detail on what they are. Next slide, please. So we have free consultation with a certified estate planner. We have most conferences offer a free preparation of basic estate planning documents, which is your will, your living will, healthcare power of attorney, and general power of attorney. Most conferences have free notary services for your estate planning documents. And also from time to time, they have consultation with an estate planning attorney. There's different tools, different documents that we offer here, the power of attorney for finances, healthcare surrogate, child guardianship that can be covered in your documents, a living will for end-of-life decisions, last will and testament, and also living trust that you can establish. Then we have some cool charitable tools for people that would like to make donations. A charitable gift and annuity is a very, very neat vehicle to donate money to your charity, and then in return, they will pay money back to you for the rest of your life. That's something you might want to explore. Endowments and also charitable remainder trusts. And then we have some other tools here in the Southern Union. It is the Southern Union Revolving Fund where people can invest their money for a return of interest, and revocable cash asset trust through their conferences. Next slide, please. And I think we're going to keep everybody muted. And if you have any questions, please feel free to put them in the chat. And then also at the end of the presentation, we will open up the microphones again so people can verbalize their questions as well. We also have to have the disclaimer that we're just trust officers within North American Division. We're not attorneys, CPAs, or licensed financial advisors. And just, if you have those questions, just put them in the chat or write them down so you can ask them at the end of the presentation. And that, I will turn it over to Nicole now.
Thank you, Silka, for starting us off. I'm Nicole Toledo, and I serve here in Georgia Cumberland Conference. And it is my pleasure to introduce Bonnie Navarro. And Bonnie is out in Arizona right now, if I remember correctly. She has over 35 years of experience in estate planning. She's an attorney. And Bonnie, you'll be pleased to know I just had some interns here with us, and we were talking about some of your sessions in training us. So these are some of the folks that Silka was sharing who have now they're working through that process of becoming certified by the North American Division, and Bonnie is one of our trusted presenters who taught some of our modules for that process of certification, and she served over 16 years as the Pacific Union PGTS director and has much experience teaching and is also just a pleasure to talk with. I've spoken with her a few times about different things when we run into different questions, and grateful to have you as a resource, Bonnie. Thank you.
Thanks for the opportunity, Nicole. Appreciate it.
And I believe with that, we'll turn it over to you for the presentation.
All right. While we're switching slides, why don't we have a quick word of prayer? Please bow your heads with me. Dear God, I just want to pray for this meeting, Lord. Help us to get some information, share a little bit, talk a little bit. And while we're doing this, hopefully learn more about you. I pray these things in your name. Amen.
Thank you, Jeremy. Thanks, everybody, for joining us this afternoon. I guess it's evening in some of your places now, right? Yeah, and I hate to tell you the people that are digging out from the snow, it's about 86 or 88 out here today. We're headed over 90 for the weekend. Eat your heart out, right? Anyway, thanks for braving the weather. Anyway, we're going to talk today about understanding the Spendthrift Trust. A lot of people have never heard of it. So we're going to talk about what are the benefits, what are the drawbacks. It's something that is used as an estate planning tool. I am in-house counsel for Western Adventist Foundation, and you'll see there's one disclaimer at the bottom there. We're presenting today as information. We're not looking for services to prepare the trust or to prepare the wills. We're really here to help educate and open up opportunities for you to talk with your constituents. And we're asking people who need to have documents done or who are wishing to have documents done that they would contact their local conference office for some guidance as to how that can be done in your jurisdiction. And you'll see by my note, hello, thank you. Uh-oh. Ta-da. Let me tell you just a minute or two about Western Adventist Foundation. I've been here on and off since 2007. I worked here from 2007 to 2019 when I retired. And I worked part-time for 2 years for Pennsylvania Conference, and then I was asked to come back to WAF, so I've been here since last October of 24 already. Anyway, WAF was created in 1997. It was the brainchild of Tom Mostert and Tom Sapera, who put together the plan to have a unified trust management company for the Adventist Church. So we were put together to manage the administrative functions, as my president used to say, the back office, the paperwork, the stuff that takes your time away from meeting with your clients. And we want to be able to help you break free of the chain of paperwork. Okay, so that's what we do. We have about 80 clients throughout the North American division that we service. When WAF first started, there was only 2 employees. We're up to 17 to 18 employees now because we've grown so big. Thank you to all of you who have put your trust in us, because we couldn't do what we do if you're not doing what you can do. And that's what we're here to help you do, what you do, and serve our constituents better. So we have approximately $350 million in management funds for those 80 different clients, their donors, and the future beneficiaries. WAF likes to refer to itself as a one-stop shop. We have people who are experts in filing tax returns. They have finance experience, trust experience. We have 2 attorneys now on staff. trying to look at everything we do from every angle to make sure that we're doing the best we can to help you get funds for your individual conferences and your projects, but also to make sure that we're using God's money appropriately. And that's really what we're here to do. So with that being said, my disclaimer, I wouldn't be a good attorney if there wasn't an attorney disclaimer. So today we're going to look at Spendthrift Trust. We're going to do it as an umbrella overview. It's not going to be super specific to your state. And I want you all to know that I'm only licensed currently in Arizona, California, and Pennsylvania. And I know that nobody here is from Arizona, California, and Pennsylvania. New Jersey, guys, I used to be licensed in New Jersey, but it's in retirement status. So again, a broad overview, and for definitive questions that rely on what the state mandates, you'll need to contact the conference office in your location, and they will help you find an attorney who will help you answer those specific questions. So today we're going to look about Spendthrift Trust. We've already mentioned that. First, we're going to start with who would benefit from having a Spendthrift Trust. Okay, so let's look at a couple of places that it can be used, and there's more than these, but I picked a few. Okay, so if you have an adult child who is not mature enough to make wise spending decisions, the purpose of the Spendthrift Trust is to protect the principal that's in there and allow the beneficiary to have controlled distributions. They will not receive a lump sum. So an adult child who's not mature enough to make wise spending decisions, they may be impulsive with money, especially if they're young and excitable. They may be looking at inheriting a big bunch of money and are making plans as to how they're going to spend it. And that's not what you want for your child. We need to look at a Spendthrift Trust. If they're in debt or at high risk of going into debt, and I'm afraid that we all know either family members or friends that have children that no matter how hard they work, they're still in debt and they can't get out. So those are some individuals that we may want to look at a Spendthrift Trust for. They've already been easily fooled or defrauded. They're naive, they're easily led, and would maybe divest themselves of their inheritance pretty quickly, which again is not what most parents want to have happen. They're experiencing an active addiction or some unproductive habit. And unfortunately, we all know kids like that. We all have friends. If they're not in our family, we know families that are like that. And the parents are trying to help the kids divest themselves of those things without blowing all that money, taking that money already out and buying some illicit drugs. So we need to look at that. And children that are eligible for Social Security, SSI or Medicaid or Medi-Cal, we need to be careful how much they inherit because they may be disallowed from the governmental subsidies, and we don't want that to happen either. So it needs to be carefully part of the overall planning of your estate plan to make sure that we don't do away with the governmental assistance that they're entitled to. We all know people like this too. You don't feel that the marriage is going to take place, is going to last. And we all know what happens in America with marital property, right? At minimum, it's split in half. So if you look at that and go, this marriage, I am sure is not going to work. So you may want to think about something like that. Courts, depending again, state specific, courts may consider the trust assets as not being marital property. So something to think about and talk about with the local attorney. And if you have an adult child who's employed in some industry, could it be medicine, could be anything where lawsuits are common. This, again, the Spendthrift Trust protects the principal and only allows income to be distributed. So now that we know the people that might benefit from having one, let's really talk about what it is and what it does. Okay. Legally, it's a legal instrument designed to protect the assets from the beneficiary's poor financial decisions and creditors. It's a specifically crafted trust that's placed into your revocable trust. Okay, and we'll talk about how that happens in a few minutes. Why do we want this? It restricts the beneficiary's ability to access the trust principal. Principal is the money that they've inherited. It goes into a box called a trust, Spendthrift Trust, and it stays there subject to the instructions that you provide when the trust is created, okay? They're not able to get their hands on the money in the box. That's really important. You have to have a designated trustee. My suggestion when you're looking at these things that you would think carefully, pray carefully about who the trustee is going to be, because they perform a very important role. You need to trust them that they're going to do what you've asked them to do so that there's a decrease in maybe the friction that may take place. But they have to follow the rules. They're supposed to follow the rules that are written into the trust. What's the purpose of this? We're trying to preserve as much money for as long as possible for the beneficiary, for your child. All right. Now that we know kind of what it is, what are the advantages? Why do we want to do something like this? All right. We already talked about a little bit. We want to protect the assets for the beneficiaries. So protection from creditors. We know a lot of people that get into debt, and a lot of debt collectors are knocking on their door and calling on the phone. When you have the money in the Spendthrift Trust, that money is not available for creditors. The only time it becomes available is when a payment is made to the beneficiary. And there are times that the trustee is able to look at that, and because of what is going on with their credit bills, they may be able to postpone that till they get some of that other stuff worked out or compromised, and then start paying them again their interest income so that they don't lose anything. But the only thing the creditor can attach is whatever the trustee releases. Does that make sense? Yeah. Good. All right, moving on. It guards against their poor habits. We all know people that have very impulsive spending habits or addiction issues, and they quickly squander their inheritance. We all know of, especially kids, I hate to say this, but in their early 20s who are, Jeremy, you know, hey, wow, I just inherited all this money, so this is what I'm going to do. I'm going to go on a worldwide trip. I'm going to buy a Porsche. Now, people don't do that anymore. What are they buying? Lamborghinis or something, you know, and they're going to blow all of their money, which is not really what their parents wanted. So by putting it into a Spendthrift Trust and allowing the trustee to parse it out according to what the parents wanted, he can't go do that. He has to go do it like the rest of us. He has to take out a car loan and make payments with the payments that he's getting from the trust. He cannot get his hands on the trust assets directly. So that kind of helps that. Grantor control, that means you as the parent or the grantor who is creating the trust really lays out how the payments are going to be made, how the funds are distributed. He takes care of investing the funds, trying to do the best he can, and he can always hire expert help to help himself as the trustee. But his job is to protect the corpus, the principal, as long as possible in order to accomplish what the parents wanted done. Long-term security. The idea of this is to keep money in there as long as possible to provide a steady source of income to the beneficiary, but also something that's not going to be grabbed back up by the credit card companies or the car companies or the mortgage company if he falls behind on his mortgage. They can only get the payout as it comes out. And another very important part is not only avoiding probate, which we all have learned to not particularly like. Some states, probate is very quick. Pennsylvania is like a year. California is like multiple years. And people are waiting to get their distributions from the trust. When it is in a trust, that happens way faster because you don't have to wait for the court process. The other thing that's really important to a lot of people is it's not public. It's not filed in the courthouse. People can't see what you've left for your kids. Not only the finances, but how it's going to be dealt with. So it's very private. So a lot of people are very concerned about that, especially in today's environment where there are all kinds of people skulking around the courthouse trying to figure out who's died, what did they have, who's getting it, when's the funeral, and all that kind of stuff. And then not good things happen from that. There are some potential tax advantages. Most of this are not in the category of worrying about the estate tax, but should you be blessed in that category, it does offer some estate tax savings. So need to look at that if you're in a high income and a high asset. Okay. What are the drawbacks? As we know, every time there's something good, there's always something not so good. So it's not all good. There are some drawbacks to setting up a spendthrift trust. What are they? Well, it's loss of beneficiary control. The beneficiary has no say in how it's invested, how it's divested, how it's paid out. It's all in the document. And sometimes when it's a family trustee, that can cause some consternation between the two of them. You know, my uncle never liked me anyway, and he's just doing this to punish me. When in reality, the poor uncle is doing exactly what he was asked to do by looking at what the document told him to do. So sometimes that causes frustration. Or if the beneficiary says, wait a minute, this is not enough money for me for income. I need you to increase that income. The trustee can't do that either because he's bound by the document. So sometimes it causes some friction in family. So something to think about when you're picking your trustee. Yeah. You need to rely on somebody that you can trust who's going to follow through with it. And while I'm thinking about that, please do not surprise the trustee. Okay. I always tell that when we're doing documents, when I was doing documents in Pennsylvania, if you're going to leave, name these people as guardians of your kids, please ask them before you do that. Don't surprise the family with all of a sudden 5 kids show up on the front door because that's what it said in the document. Same way with the trustee. Please don't surprise the trustee. He needs to be fully aware of what's going on and then fully capable and willing to take on the process because it's an arduous process. It's a long process. There's a lot of rules and regulations and there's tax returns. There's all kinds of things that the trustee needs to worry about. So you want someone that you know that you can depend on, and you may want to pick a viable second in case there's something that happens to the first one. I never like to have only one person named. 2 is better because you want to be the one picking the trustee. You don't want the court to be the one appointing it unless there's no other alternative. Okay, all right. So now timeout. So we're going to talk about choosing a trustee. How do we do that? Well, we have several options. Number one, we've already mentioned, family member or friend. Okay. Pro is that they're familiar with the beneficiary, they know what the needs are. Maybe they have a good relationship, but and they're willing to step in and serve. But the con to that part is they know the beneficiary, they know the trustee, and things are not going to go well because they know each other and they're at odds as to how the trust is being managed and distributed. Another option is to hire an attorney. They're professional. Make sure that you get an estate planning or an estate administration attorney. What's the con for that? Attorneys get paid. Now, understand that the family member or friend who is a trustee also is entitled to be paid a trustee's fee, but usually they take less of a fee than the attorneys do. Just telling you. Or a professional trustee. Several states have people that are accredited as trustees. They go through programs and are certified. They also are professional, and usually they are a little bit more reasonably with their hourly fees than the attorney is. So you've got a couple options there, but don't name just one, name a backup as well, okay? All right, so what do you need to think about when you're going to pick your trustee? Well, when you have your documents drawn, you're going to ask to have another trust put in your trust. So the attorney may well decide to charge more for that because there's some complex things that need to be handled. It's not just as easy as dropping a paragraph in. It needs to be integrated with the overall estate plan so that it all works together. So don't go to a do-it-yourself online, and I'm gonna do it now and just drop this in, and I've seen that happen. I've seen it happen with stuff with using the wrong jurisdiction, using something from a community property state that is a joint tenancy state. So my advice is please bite the bullet and pay the professional to put it together so it holds up when you need it to hold up. There's ongoing professional trustee fees. That trust is going to last for a very long time. It's either going to last until the beneficiary dies, or it's going to last until the money runs out. Okay? And that being said, the trust will have a tax return that will be due every year. And so then there has to be careful management as to how the assets are invested to minimize the tax that's paid by the trust. So something else to think about when you're looking for a trustee. It's also very inflexible. Translated, it's cut in stone. It is very hard to have it changed, very difficult to modify. Now, some states like California has some statutes that can sometimes be used to modify it or change it a little bit, but in most cases, irrevocable means irrevocable. So if your beneficiary has some kind of medical emergency, or he needs a new car because he had an accident and he needs $60,000 to go buy a car, if that doesn't allow the trustee, the trust does not allow the trustee to increase because of that, it can't be done. So it's written in stone. Okay. All right. While I said that it is protected from the claims of creditors and maybe marital divisions, there are a couple places that, as we all know, the government wins. So government tax liens from the IRS and from state taxes are one of the few things that can invade the principal to be paid. Sometimes, depending on the state, child support or alimony can also invade that trust corpus and have the money paid out from there. So again, that's something that if you're in that situation, you need to talk to local counsel to make sure that in your jurisdiction, it either is invadable or not, and things are drafted accordingly. All right. We already talked a little bit about this, but potential for disputes. If you have a beneficiary who's really irritated and not happy because his parents didn't give him a lump sum, he's going to take it out on the trustee. So be prepared for that. Some families are very harmonious and everybody's happy, and some are already in disputes before the parents die. And now it gets worse because the kid was anticipating a large payout, and now he's really crabby because he's not going to be able to get his hands on it. That will be taken out on the trustee. So you need a trustee who can let water roll off their shoulders like a duck. Just saying. Okay, so kind of a summary here. Spendthrift Trust is a powerful tool, but it has trade-offs. It has benefits and it has drawbacks. So the reason we're doing it is for asset protection. It gives the best protection that we can get from most creditors, and except for possible governmental and family claims, meaning alimony or child support. It gives control over the assets that are in there. You have created the trust and you have laid out the terms on how it's going to be administered and distributed. Okay. What happens when that happens is the beneficiary is now losing control and he's losing access to the money. So that's the con. Administration is another feature. Benefit, it avoids probate and it offers privacy. It's not recorded anywhere in the courthouse so that people can't go and look at it. You're a curious neighbor as to what did they do with their money. However, it's complex. It's expensive to create at times. It's expensive to maintain. And it's reliant on the trustee. And remember, the trustee is also always entitled to a trustee's fee. All right, you gotta love legal language. So here's a sample of legal language. Except as otherwise provided in this trust agreement, all principal or all income that is payable or will become payable to the beneficiary of any trust created by this agreement. Here's the important part, shall not be subject to anticipation, assignment, pledge, sale, or transfer in any manner. So the kid can't say, I'm gonna buy this car because I anticipate getting something, so I'm gonna sign it, he doesn't have the money, he's not gonna get it based on the terms in the trust. No beneficiary shall have the power to anticipate or encumber any such interest. No such interest while in the possession of the trustee shall be liable for or subject to the debts, contracts, the obligations, the liabilities, or torts, which is personal injury, of any beneficiary. Such interest shall also be free from any claim, control, or interference of the spouse of a married beneficiary or the parent of a beneficiary. And just an aside, when you look at all these documents that are like 40 pages long, do you know years and years and years ago how attorneys got paid? This is one of my favorite things I learned in law school. You know how attorneys got paid? By the word. So the longer the document was, the more the attorney could charge. They taught us law school 101, right big. All right, let's see. Okay. What we talked about was making sure that it's a revocable trust and the spendthrift clause is included inside the revocable trust. It's important that it all be homogeneous, that it all works together. So you don't want a separate, you can do separate spendthrift trust. It's not illegal to do that, but it's not part of the overall distribution of how you want your assets done. So it really should be placed inside of a revocable trust. Okay. And again, it's important that it be spelled out in there how the beneficiary gets his money and when he gets it. Yeah. One thing to remember, and we already talked about a couple times, when the beneficiary receives the money for the trust, they can do whatever they want with the income. They cannot touch the big distribution that was placed into the trust. So, if they're getting $100 a month or $1,500 a month or whatever it is, that's all they get, and they have to cope with that in their style of living. Okay. You can also design the trust that, while it's not necessarily paying money to the beneficiary, it can be paid for the beneficiary's benefit to the school, to their landlord, to the mortgage company. It can be paid for them. So sometimes that has to be done because even that $1,500 they're getting, they may be blowing that and all this other stuff's going crazy with them falling into debt, falling behind for stuff. And the trustee can kind of help at that point by diverting the funds to an approved creditor of the beneficiary. Okay, so it provides asset protection from creditors, except this IRS can't run from them, from lawsuits and from their poor financial decisions. The drawbacks are limited beneficiary control. It's a higher setup, higher maintenance costs, and it's inflexible once it's basically set up. That's it. It's done. So you have to weigh pros and cons like we do everything else. When the parents are looking to create something like this, they need to look at their family. They need to look at the kid they're trying to protect. They're trying to decide, is it worth it? What is he going to do with it now? And do the best you can based on the environment when you create it. And I used to always tell my clients that they should take out their estate planning documents every 2 to 5 years, blow the dust off of them because nobody's looked at them since they've been signed, and see, does that still fit what's going on? And if it does, great, put it back in the box. If it doesn't, it's time to have it changed and amended, because maybe that kid has grown up enough that he's now mature enough to manage. And maybe the assets are not as much as they were back when the kids were younger, because now we don't have life insurance and we've had to use some of that money for our own personal care, and there's not going to be such a big inheritance. So maybe it's not such a bad deal for him to inherit directly. So you need to look at the environment, the tax laws, and everything, and figure out what is the absolute best way to go. And the trustee controls the distribution of the funds. We already know that. Okay. And we already know that it may not protect against child support and the IRS. All right, I think I have motored through that, hopefully not too fast, but we wanted to leave time for questions and some discussion. So I don't know if we have
We
any.
do.
We do?
So before we start, I wanted to get really very practical.
Uh-oh.
So if I'm a person and I have a spouse and we have 4 kids,
Mhm.
and I want to set up a spendthrift trust, I need to go find someone, a lawyer or someone to help me with that, it sounds like, or
It's my suggestion
Right.
anyway, yeah.
and let's say if I had 4 kids, 3 of them are fine. The first 3 kids, they're doing great. I'm only worried about one of them.
Mhm.
I could create, with an attorney's help, a spendthrift trust for one of my kids so that when I pass away and, my spouse passes away, then that trust would kind of drip out money to them on some kind of schedule. Maybe it's invested, I'm assuming too.
Yep.
And they're entitled to, whatever
Yeah.
strings I want to put on it.
Yeah, and that's a good point. You don't have to treat all kids equally. They all don't need their own spendthrift trust. You know your children better than anybody's going to know them. So if there's only one, you take his portion and you put it in the spendthrift trust. And the other kids can inherit outright.
And if maybe, 10 years later, they change into a new person and they become very responsible, am I stuck with this, kind of spendthrift trust being set up?
If you're dead, yes.
All right, so.
But during lifetime, no, and I think that's what we talked about a little bit, about taking out, looking at it, looking at your kids, looking at the economic environment, looking at the asset value, and determining, is that still something that you want to do? Or have they matured enough that they can be treated as the other kids?
All right,
Does that
so
answer your question?
it does. I'm a very practical guy, I want to know exactly what I need to do. All
That
right.
is Jeremy for sure.
All right, so Phil's question is, how about a spouse who's developing dementia? Would a spendthrift trust be appropriate in that situation?
I don't see why not at the moment, Phil, to be honest with you, because that's what you're trying to do is protect the assets. So rather than an outright something, and it would be spendthrift for the rest of their life.
So it sounds like that's a tool that,
It is a
talk to
tool,
an
I
attorney
believe
about.
that, yeah, exactly. In your jurisdiction, find out if that's something that the attorneys recommend, yeah.
All right, our next
I've had 2 situations like that just in the last month where spouses were concerned about that.
All right, our next question is, so Bonnie, if you create a trust and then you assign a trustee, maybe someone you trust or an attorney, somebody as trustee, but then you change your mind after a few months, how hard is it to go back in and change the trustee?
It's called an amendment to the document, and you just go to the attorney, hopefully the one that drafted it. And he can do an amendment that just changes only that part, if that's what you want changed. If you go to a different attorney because that attorney maybe has retired or you can't find him or something, it's possible that that new attorney will not want to just amend the trust. He may want to restate it, which is start all over again, because he doesn't want to be responsible for if there was a problem with the first trust. If that makes any sense. So sometimes they'll have to redo it.
Okay.
Yeah.
All right, so there's 2 situations, one where, might be easy, one where it might be more challenging.
Right.
All right. What about if you already have a will? Can you integrate a spendthrift trust into that document?
The answer is, can you? Yes. Should you? No.
Okay, why not?
Because it's part of the whole outlook of what's going on with that revocable. You need a revocable. Plus, if it's a will, it's going to be public. It's going to put those assets through probate. Whereas if you have it in your revocable trust, what do we know about revocable trust and probate? What do we know about them? Somebody be brave. Tell me, what do we know?
They're private.
They're private. Thank you.
And
They don't.
Generally avoids probate,
Exactly.
generally.
Generally, that is correct. Well, it's better option that way than the other way when it's 100% going to probate. So, yeah.
All right, here's Nicole. She can follow up, but her question is, can provisions be added to the trust that would eventually allow the trustee to end that spendthrift provision if, say, the beneficiary in the future meets some guideline, such as proving they are drug-free for a certain period of time, or somehow proving to the trustee that their financial habits have changed.
That is so hard for the beneficiary to prove to the satisfaction of the trustee. I would not want to be in the position personally of being that trustee determining the kid said I'm drug-free. Oh, yeah, sure.
What if they attend church and they send me a picture of a
No,
selfie?
no,
They're in the
no,
pew,
no.
52 weeks?
No,
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 okay.
no, don't do that. No, it's irrevocable, folks.
I had someone ask me this, and actually, they were saying, well, could they go to a specific clinic and have actual labs drawn that showed their name? And, they have to have 3 years clean or something to that measure. And then they would be able to have access to their inheritance without the spendthrift
Well,
provision.
I talk to local council and see if that's okay in your jurisdiction. That's all I can tell you.
How expensive would it be to do 3 years of drug testing? I'm just curious.
I have no
No clue,
experience in
okay,
that. I
okay,
have no
okay, but it
clue.
might be pricey, so, but if they really need the money,
Well, it depends on how much they're looking for.
all right,
Check
so
with local council.
Phil's question, let him follow up, but, so are assets transferred to a trust during life or, through a poorer will? So can they be transferred to the spendthrift, I think, part of the trust?
They would go in as part of the distribution.
Okay,
And the distribution would say, take a percentage or a dollar figure or whatever it is and plop it into the spendthrift trust.
okay. So again, if you have 4 kids, you'd say take 25% maybe of the
And put it
total.
here for the spendthrift trust for this kid and divide the other 75%, 25% to each kid.
So, another question is a little bit about spendthrift trust as a noun versus a spendthrift provision in a trust. But the question is, is there a difference between a quote spendthrift or a regular revocable trust? Or, and if there's a difference, what is it?
Okay. Revocable trust distributes the assets as per the distribution outright, unless you have the building up of the spendthrift trust inside the revocable. And we just talked about 4 kids, 3 kids, give
Mhm.
Jeremy 25%, give Adam 25%, give Bonnie 25%, and put 25% in spendthrift trust for Nicole. Sorry, Nicole.
So you're saying that, so when I'm doing my trust, I have the 4 beneficiaries at 25%, but one kid's 25% could go to a spendthrift or trust in the revocable trust that's outlined
Yes,
there.
it needs to be stated that way,
Okay.
and the provisions for the trust need to be put in the revocable trust. The directions need to go in the revocable trust.
All right, so here's our next question. We've kind of talked about the distributions of monetary issues. So can material things such as a car or valuable items be included, and how would that be worked into the trust?
I don't see that happening, and if the trustee somehow managed to inherit in the spendthrift trust a car, the first thing he would have to do is sell it. Why? Because his job is to provide income to that beneficiary and not hold onto personal property and that kind of stuff. So I don't see that happening.
But you could, so you couldn't pass a card to
Not that.
to the person, but the trustee of the spendthrift could sell the car and use that as money.
I'm going to assume that the trustee of the revocable is going to sell the car
Okay,
and include that as part
I like
of the
that.
overall distribution split amongst the kids. And then a quarter of that car's received value would go into the spendthrift trust, but not personal property.
My question is, I know it varies based on the state, but at what point do I need to spend the money or start putting together a revocable trust? Is there a life event? Is there something, that would make it, valuable to me to set that up?
A couple answers to
Okay.
that. Sometimes it's because what you see has just happened in your own family, and it suddenly has dawned on you that you need to make preparations because maybe your parents didn't make great preparations, and there's some fallout there that you want to not have happen in your relationship and with your assets. We used to always tell people that if you own property in more than one state, you want a revocable trust to start with. Why is that? Property is prorated in the state in which the dirt lies. So if you are blessed to have a house in Florida and and a retirement one in North Carolina, you're gonna do probate in 2 states. And that is expensive and time consuming. So revocable trust doesn't have to go through probate to have those assets sold. What else did you ask me?
Amounts, I'm just curious,
Oh,
like, how much
dollars?
should I expect to pay for a trust? I'm just curious. I know it depends on the lawyer, but,
Thank you. It does, it does. It really does. I mean, you go out in California and you could be paying $5,000 or more. You
okay,
come on the East Coast, you could be paying 1,000, some people 500. It depends on the attorney. And
That's
the
good, yeah.
relationship the attorney has with the conference and what, all those arrangements have been made.
so,
it's-
yeah.
Anywheres.
All right, going back to another question, kind of following up. If I have a will, existing will,
Right.
and having a trust, are those two separate things? Or if I have a trust, can I get rid of my will?
No, the quick answer to that is every revocable trust should and must have what's called a pour over will. Now, when you look at an original will that stands all by itself, that will can be maybe 6 or 8 pages long, right? We've all seen those. When you have a pour over will, they're usually only like 2 pages long, because it basically says, take all the assets I own that are not in the name of the trust, and it came from a picture, you pour them over into the revocable trust. So that will take care of things that you didn't have time or energy or thought about titling in the name of the revocable trust. So it will go through probate and into the trust, but it takes care of all of your assets. So they need to go together. It's a package. You will not, I don't know of any attorney who prepares a revocable that doesn't prepare a pour.
Okay, so it sounds like a pour over will is kind of a companion to a trust, or maybe a trust is a companion to a pour over will.
They like to be together.
Okay, that's a good answer. So we're not getting rid of our will if we do a trust.
No, don't get rid of any document you have until you have a new one signed, please. Do not rip up the old one. And while I'm thinking about that, please do not write corrections on the original will. Please do
Okay.
not write corrections. Look at Nicole, yes, do not, because what'll happen is it's potentially going to defeat the entire purpose of the will. Some of it will be written out and by the court because you didn't write on it correctly. So you may not be happy with it, but keep it till you get the new one. Then you can destroy it. And please don't write on any originals, please. Thank you, Nicole.
All right, we still have time for a few more questions. If anybody, we'll open it up now to the audience. If you'd like to unmute yourself and ask a question or have a discussion briefly, we'd be happy to engage in that now.
Sure.
Lots of good questions. So we had another question. We have just one child. Do we need a trust?
Depends on the rest of your assets.
Hmm,
You for sure need a will, and the will surely needs to have guardianship provisions in there. Again, do not surprise the person that you're going to name as the guardian for your kids. Please ask them, see if they're willing to do that. When you're young, you don't have a whole lot of assets, but you never know. There are things called industrial accidents. There are things called personal injury cases. There are things that you don't know whether or not you're going to have assets when you're killed in the accident. You need to make sure you have a will. Whether or not you decide to do a revocable right away is entirely based on your personal situation. But usually as you mature and as you add assets and you become worth more money and you have more things and you have more real estate, you need to consider having the revocable done. But for sure, when you're young, I mean, I don't know how many, I'm old, so I can't tell you how many wills that we've had, but we've had a bunch. And each one changed based on, we were young and had a kid. And then when he graduated high school, we probably did something else. When my husband went through professional school, we did something else. And then, as your life changes, the document should change too. That's a long convoluted answer, sorry.
It's a good answer because a lot of people wonder, at what point do I need a trust? Is it something is it when I buy a house, or is it when maybe the first adult passes away, or, when is
It
the,
kind of depends.
what triggers that?
It kind of depends on what you want to do with the assets. I mean, there
Okay.
are multiple ways. There are transfer on death deeds. There are transfer on death or pay on death PODs for bank accounts. There are some people that don't need a will because they've got a checking account and a car and no kids and no spouse.
Yeah.
Do they need a will? Maybe they don't, as long as they set up the PODs on the bank accounts and you can take,
Unless they die in a car accident and there's money coming.
I'm sorry?
We were just saying that unless they inherit or receive money after they die.
True.
Yeah,
True.
like a car accident, malpractice, something
That's what
like
I
that.
talked about, yeah.
Oh, yeah.
Yeah,
That's a good
absolutely,
point.
absolutely.
Now,
Yeah.
Pastor Premier had asked a question, and I think we missed it. What if the trustee
I got
dies? Yeah, thank you.
Got it. So what if the trustee of your spendthrift trust passes away?
That's why I say you always need a backup. And if for some reason the backup passes away, the court will appoint somebody.
All right, so how about this question? What if you have 3 kids, who are part of that revocable trust or spendthrift trust, and one of those kids passes away, and the kids are the beneficiaries? How does that work?
It's called per stirpes, or as some of my clients called it, per stripes. Okay, it says if Jeremy is killed and has 2 little kids, per stirpe says those 2 little kids inherit Jeremy's share. So it goes down the family tree. If you don't have kids, it goes up the family tree, looking for your parents. If your parents have predeceased you, it goes out to brothers and sisters. There's this whole schematic as to who gets what.
So, but can you put in your trust or your will provisions that would deal with the death of a child, or-
Yeah, that's what
Okay.
it says. I give 25% of my estate to
Okay.
Jeremy per stirpes, which
Okay.
means if something happens to you, per stirpes is the best way to do that as opposed to per capita.
What would be the role of a trust in a divorce proceeding, spendthrift or otherwise?
Spendthrift, and you have to check local jurisdictions, but spendthrift sometimes, most of the time, it's not viewed as marital property. Not be subject to the split in the divorce.
I think we kind of touched on that during the presentation.
Earlier, yeah.
But that's good to know.
Again, gotta check the jurisdiction because everybody has different rules.
Now, what about if you're a couple and you have a joint trust with spent their provisions and you start going through a divorce? Who gets the final say in that?
Are you talking about the beneficiary going through a divorce?
No, the people who are the original grantors. Let's say husband and wife get married, they set up a spendthrift trust, but then they get divorced. What happens to the trust, if they get divorced?
Well, I'm going to assume, and that's always a bad thing to do, that they're each gonna go out and do new documents.
Because the, wills and other documents by operation of law, there's other things going on in the
Well,
background.
they're not gonna want to leave their spouse as a beneficiary of anything at that point.
Right,
So I would imagine that they would have new documents done, and then each one of them, if they're worried about that kid, they would each have a spendthrift trust, and he who lives longest wins in that case.
just in case they don't change anything? Okay, all right. It's a good answer. Thank you. All right, well, it was really nice to have this conversation. We have about 5 minutes left. If we have one more question, we'd be glad to take another question.
Come on, Jennifer, what do you got?
And I think we have some closing slides as well.
Oh, good.
Okay, so last question. For a revocable trust, if one child wants cash and the other child wants the properties, how does that get handled?
Between the 2 of them, with the overarching power of the trustee, the one who wants to keep the house is gonna have to pay the other one out. Okay, so they'll have to come up with an appraisal, which has to be done anyway, and then determine what is the value and can the person who wants to keep it afford to keep it? Sometimes yes, sometimes no. They may have to go get a mortgage for to buy the property, but that's what happens. Or if that doesn't work, where they don't have the money, then the house goes for sale and the money gets split.
All right, so thank you so much, Bonnie.
Thank you guys for inviting me. It was fun. I hope you had fun.
I thought it was excellent. You did a great job, Bonnie, and really that was very concise. I know you felt probably like you were rushing through it because there's so much more to this. And as you said in the very beginning, a lot of it depends on local state laws and that kind of thing. So it would behoove anybody to check with a local attorney. I don't know if we have other slides, Jeremy, for closing out, but we usually have slides that have our contact information for the various conferences. Obviously, WAF, I know you guys are there, Western Adventist Foundation. We didn't toot your horn enough in the beginning, but you guys are amazing.
You're too
But
kind.
y'all are back office primarily, and generally, unless things are changing that I don't know about, but generally not that much customer interfacing. And you allow your conferences or your media ministries to do that, and we appreciate that. So I believe we would encourage folks, rather than contacting you, Bonnie, directly, to go through their local conference. Would you comment on that?
So in the chat, at the very top of the chat, a lot of our local conferences chimed in and provided some contact information.
Yeah.
So there are some of you who still have some additional questions. These are the people you're going to want to talk to. So scroll to the top of the chat. Nicole put her information in there. Rachel put some information in there. Silke put some information in there as well. You can also Google your local conference, depending on your location. Reach out to their PGTS team. Those people are standing by and they are excited to help people who are trying to navigate this type of work.
Absolutely. I think that's what we said at the beginning. We are the back office. We are here to support those of you who are out in the field, who are interacting directly with your donors. We want to take the burden of the tax preparation, the burden of the paperwork off of your back, which gives you the time to go out and meet and cultivate. Take your donors to lunch. We're sitting here scribbling on paper while you're out having lunch. So just so you know, but that's the goal of the foundation. We're here as a resource, but a back office so that you can spend time with your donors.
And we appreciate it very much. And Silke, I may have said in the beginning, but I want to reiterate, for most conferences, and some conferences vary, so I don't want to speak for all of us here, but for a lot of conferences, there's no obligation to include the church in your estate plan, and there's no fees for the services that we provide. For more complicated estate planning, an attorney may need to charge a fee directly, but the conference does not take a cut of that, and we as plan giving and trust service professionals do not expect, we don't charge anything. So the advice that we give is free, and we are happy to serve our membership. This is a ministry.
Absolutely.
And we're here to serve you. Adelia, were you going to say something?
I was going to ask Jeremy if he wants to share the PowerPoint, the one that we so that way we can share the next webinars that are going to be.
Okay.
Yeah.
And
I sent the PowerPoint out.
It's
I'm glad to send it out again.
It's
ahead.
the last 3 pages of the intro
yes,
PowerPoint that we shared. The last 3 pages of that PowerPoint that you had at the beginning when I did the
Okay.
introduction, we kind of need to go.
Okay. All right.
Can you
Let's see.
can you pull
Give us
that up,
one-
Jeremy?
You
Give us
share?
1 second.
Yeah.
Okay, super. Very, very good. Thank you for that. Thanks, Silke. Yeah, that's good.
That's it. Okay. All right, there it is.
Yeah.
Good. And so this is Florida's information right here. If people want to take a picture of that, or you can take a picture of the QR code. It'll take you to our website. Next slide.
I think it's one on the back where we promote the webinars.
Yeah, the one before the Florida conference.
Back,
This one?
back.
No, one
No,
more.
back,
There we go.
yes.
Future webinars. Yep. You just had it there. Future webinars. So March 24th is our next one. That'll be a deep dive into estate planning. That's going to be a very interesting one. April 28th, what to do when you say I do later in life. We run into a lot of second marriages, a lot of things like that. Working with a couple right now that have concerns about that. And if you want to hear this webinar again, go to our YouTube page at Florida Conference, or the other conferences may have a link as well. And I don't know if there's another slide or not.
There is.
Okay, good. All right, Silka, you started us out. Would you close us out?
I'll be happy to. Let's pray. Heavenly Father, thank you so much that we could spend this time together to learn more about the tools that are available for us to be wise parents, wise grandparents, and leading our children or grandchildren as they make life's decisions as well. It's good that we have these tools to put in control, to help them live better lives. We ask that you give us wisdom as we each one of us make decisions about our own estate plan, and that we will be wise stewards with what you've given us. And we ask that you bless us this evening and take care of us. And thank you for your love and for Jesus dying on the cross for us. In Jesus' name I pray. Amen.
Amen.
Thank you.
Amen. Thank you.
Thank you, guys. Western